Good morning. Actually, uh, normally those who are conducting criminal cases must know the provisions of 91 CRPC, wherein we want certain documents. Particularly, we are being struggling with documents available at police stations because everybody knows the police department is very free to manipulate their own records. Therefore, they are afraid to produce the document. Periodically, several cases are gone to Supreme Court about the admissibility of these documents. Actually, you see what happened uh, when Justice, one of our learned judge, has said that demand of this 90 case, general dairy and general section dairy, which will facilitate us to disprove the case of the prosecution that they registered the FIR in time and arrest was effected in time and accused was arrested at particular place. For all those things, general dairy, general section dairy, and police business such a PS that will help us. But unfortunately, PSR they afraid to produce those documents. But actually, a case was decided that is reported in 2018 Law Weekly Criminal 853 Haji Muhammad vs. State, wherein they say this general dairy is also part of the case dairy, therefore we are not entitled. But that after due discussion and referring the Supreme Court judgment, the first bench of our court, headed by our then Chief Justice Tihla Ramani, Vijaya K. Tihla Ramani, overruled that judgment. Therefore, thereafter, overruled that judgment wide in P. Kalachalam vs. State Inspector of Police, that headed by Chief Justice and G.R. Swaminathan. Then, following that judgment, our Justice P. Rajamanikam wide order date 23/1/2020, Abhirami versus Kundratur PS, in criminal OP number 28440 of 2019, directed the lower court to call for the records. Now another question, we are now before other bench. The question was, the court simply again rejected the claim of the petition, stating that there is no necessity. For that we have to answer before the court tomorrow. So according to me, what I mean to discuss with you, if any senior counsels is following or any junior counsels are following, kindly place this matter to the expert seniors so that I can also effectively submit my representation. Number one, that according to me, we are following adversarial system of criminal jurisprudence, number one. Number two, that adversarial system of criminal jurisprudence is being followed by Westminster criminal jurisprudence, followed by United Kingdom. The doctrine of respondent superior, that is very big doctrine, but the dictionaries are simplifying that, limiting to the area wherein principal is liable. But according to me, the actori incubit onus probandi, onus lies on the plaintiff, respondent superior. So a respondent must be other, like that also wager litigation. Wager litigation means then one who files a suit or prosecution must prove the case. So I need not prove. And apart from that, the court cannot compel me to disclose the defense even before witnesses are in the box or even before referring the documents. Therefore, according to me, I also intend to apply the maxim just ad rem. Just ad rem means if you have one right, consequently you have another right. So here in criminal proceedings, we have one right. That means fair and speedy trial. That means I have right to remain silent. But whether compelling me to disclose the necessity, I could not understand. Apart from that, right from my career of practice from in the year 1981, along with several veteran practitioners, my seniors, N. Nadarajan, N.T. Vanamamalai, Punjab Akesan, A. Asogan, Bhagiraj, we normally usually file application 91 CRPC, and the records were being produced, and the judge himself we will get permission from the court and peruse it. If anything available, we will put to investigating officer by referring that documents. That's all. If we are not, if the investigating officer admits that the referred facts are available in these summoned records, that is sufficient. Unless and until some interpolations were made, then we have to mark those documents. That time also the court normally used to take Xerox copy of that and mark it by referring the original document. This is the way. So tomorrow I am going to refer some more judgments also. This Madras High Court, Muthuraman versus State State. That case, another case was from Maharashtra High Court. Kamal Ahmed Mohammed Vakil versus State of Maharashtra. I am going to refer this judgment along with yet another judgment. So that this is matter that because once this concept is allowed that the petition under section 91 must be filed along with necessities, reasons for summoning the document. I don't think that will is a proper order compelling. But here, what section 91 CRPC says, necessity, we need not submit, but the court has to consider it to the necessity. That is there. Our necessities, and unless and until so, the petitioner ought to have stated that at the time of cross-examination of the IO, there is possibility of confronting with these documents for the purpose of disproving arrest and other factors. That would have been stated. So be careful hereinafter if you want to prepare application under section 91 CRPC. Best wishes.